We got a last-minute development in the Georgia prosecution of Donald Trump, Rudy Giuliani, Mark Meadows, John Eastman, and others. We were waiting on an oral argument before the Court of Appeals in Atlanta concerning the appeal by the defendants of Judge McAfee's decision not to disqualify the district attorney. But we got a brand new development, which is a setback to justice. I'm Michael Popok. You're on Legal AF, the YouTube channel. Take a minute, hit the subscribe button, and join us at the intersection of law and politics. And I'm at the intersection about a brand new order we just got from the Court of Appeals. One page, that's it, one line. Just says that the December 5th oral argument that would have been the appeal of the decision by Judge McAfee at the trial court level not to disqualify Fani Willis because she dated somebody in her office. That entire appeal and all the related appeals brought by about 8 out of the remaining 13 co-defendants is that oral argument, which is the last thing that needs to happen before they issue their order, has been canceled unilaterally by the Court of Appeals, the second highest level appellate court in Georgia. In fact, it doesn't even say it's going to be scheduled. The order says it is canceled until further notice. That's it. Now, let's piece this together. We had an appeal that had been scheduled for a month or two after the election. We thought that was sort of a long period of time to get on the docket, 3 or 4 months after the appeal to have an oral argument. We figured that the Court of Appeals setting it so far in advance, setting it into December. I mean, this was set sometime in July or August. We thought, oh, well, that's a signal. And now we've got a further signal. They watched the results. They saw that Donald Trump's returning to power, even though the rest of them don't enjoy any kind of immunity. We had a recent decision by the United States Supreme Court, which just in the last couple of days informed the world, and particularly Mark Meadows, John Eastman, and others, that they have to keep this Georgia prosecution in Georgia, in state court, and not go to federal court because the Supreme Court says there's no grounds to transfer it to federal court. So we had those two data points. And now we get, out of the blue, for no good reason, the entire oral argument canceled until further notice. Now, I've done appellate work, and I will tell you that it's highly unusual for an appellate panel or to cancel, or the clerk on behalf of the panel, to cancel an oral argument outright and not reset it. Sometimes on the heels of this, you'll get a reset. But given the publicity around this case, I think the message is clear. We're not going to see that oral argument rescheduled. Now, they don't need oral argument. That's the oral presentation, obviously, of the appellate arguments before a 3 or 5 judge panel. It depends on how many we have there in Georgia. And it's there to answer any remaining questions after the full briefs have been provided with the record below. The evidence that was developed in the trial court level have been supplied and transmitted to the appellate court. It's then, therefore, the appellate court may have some questions for the advocates. Sometimes it's a hot bench. I've been there, where the judges pepper whoever's up at the podium with questions that concern them. Sometimes it's not such a hot bench, and you get to present most of your argument before anybody interrupts at all. Hot benches sometimes indicate where the panel is leading or where the majority is. Sometimes it doesn't. It's just a thought exercise that's being performed in public. And you get the judgment back or the order of the appellate panel. And you're like, wow, they ruled for me. I never thought that was going to happen. But we're not going to get there. Now, they don't have to have their oral argument. On the briefs, they can make their decision. But if they've granted oral argument, they almost never refuse it. Could we see a decision coming out in lieu of oral argument? We could. I think there's a 10% chance of that. I think there's a 10% chance this gets rescheduled in the near future. Otherwise, it's just going to sort of stay. It's sort of trapped in amber by this appellate court until they figure out what they want to do with this case. Now, the case against Donald Trump, let's be frank here on this hot take. I don't blow smoke or sunshine. People, I think, come to expect that and demand it. The case against Donald Trump is effectively dead, at least while he's still in office. There is no state court, federal court, appellate court, or Supreme Court that's going to allow Donald Trump and the office of the presidency to be interfered with a criminal prosecution during the 4 years that he's in office. They're just not going to happen. We can sit here and wring our hands about the errors that were made at the state court level, the investigatory level. I mean, it moved pretty rapidly. It got pretty far along, and then it sort of got stuck in the mud over some mudslinging by Donald Trump and the other lawyers, attacking the prosecutor on ridiculous and nonsensical and irrelevant grounds that she happened to have had some sort of relationship with somebody in her office that also was on the Trump prosecution team. Who cares? Sounds like an HR issue. It's not a remove the prosecutor from the prosecution issue. But, Donald Trump and his band of merry tricksters will try any monkey wrench they can find in their tool bag, any sand they can find to throw into the gears of justice. And they did just that. And 8 months later, 9 months later, we're still talking about this case. I mean, that hearing with Fani Willis, it was like a full-blown evidentiary hearing. I had to hear about, all of her off-duty meetings with the guy in her office and trips to go to Napa Valley. I mean, who cares? What does it have to do with the crimes that were committed? Nothing. And as I've said, and as my colleague Karen Friedman-Knifolo on Legal AF has said, if it was a man, a prosecutor, this wouldn't be of interest and this wouldn't be pursued. But it was, and it went to a full-blown hearing, which I think was improperly conducted by Judge McAfee, who's supposed to be the gatekeeper. I never would have allowed all that evidence to have come in the way it did. I think on the fundamentals, they needed to prove the legal aspects and the other side's legal entitlement to this evidence. But that's not how McAfee did it. He's a young judge. He's only been on the bench for about a year and a half, his first major case. And he just was like, he bent over backwards to let everything in. I'll sort it out later. But everything in Georgia is a public hearing. And then it became a public spectacle and a circus led by Donald Trump and the other lawyers. And then he finally allowed Fani Willis to stay if she got rid of the guy she dated from the prosecution team, which she promptly did. But, the damage was done. And he wrote some unkind words, and I think inappropriate words, about Fani Willis's judgment, which gave, it put it on a silver platter for the lawyers for the defense to use in their own motion that he was wrong and he had balanced things improperly, the judge, and Fani Willis should have been removed from the case and it should be reassigned a new prosecutor who they hope will kill the case. But now, the oral argument that would have been sort of the last shoe to drop before, we get a ruling, that's been canceled. We don't know why. The three white guys that were going to handle the appellate court decision canceled it, but there's no good reason for doing it. If they had an illness or a conflict or they didn't need it, they would say, we have dispensed with oral argument and we will be ruling on the briefs. If somebody got sick, they would have set a new date. But to say until further notice, no oral argument, that basically puts this thing, as I said, trapped in amber. We'll never see this case again, not any time soon. And again, it would only be against Giuliani, Roman, Eastman, Meadows, and the other top aides of Donald Trump. It's an important case. I'm not saying it's not an important case. At one point, we thought that was the case that's going to go to trial first, but that's not how it went in sequence. Effectively, just to bring everybody up to speed, 2 years ago, it was the Manhattan District Attorney's Office that successfully brought the first to indict against Donald Trump. It became the first to try and the first to convict. That all is to the glory of the Manhattan District Attorney's Office. The other cases, which may have been further ahead of them in the horse race, ended up crapping out, breaking a leg, and not being very successful. The D.C. election interference case sort of started late because Merrick Garland appointed a special prosecutor late, and it all got tied up in the mess of the immunity decision, and nothing was accomplished except for lots of motion practice and nowhere near picking a jury. And now Jack Smith is about to report by the first week in December, what he's doing with the case. The Mar-a-Lago case got caught up because it got assigned to a handpicked judge by Donald Trump who was in his favor and has bent over backwards to help him, and apparently was on the short list to join his administration in Aileen Cannon. And she dismissed the case, finding the special prosecutor to be improperly appointed and funded. The appeal with the 11th Circuit Federal is still pending, but Jack Smith's going to have to make a decision on that. We know that Jack Smith is writing, in the process of writing, his 2 reports about Mar-a-Lago and about the D.C. election interference case. File it with his boss, Merrick Garland, who's promised to release it to the American people. I think all that's got to happen between like today and well before Jan 3 when the 119th Congress comes back. And then you've got that Fani Willis case, that Georgia case, and you see what's happened there. I'm going to continue to follow it, all the procedural ins and outs, the logistics, and sort of hopefully teach about appellate law and appellate practice and all of the federal and state criminal cases and appeals that we have going so that you can make sense of it all. I do it right here on Legal AF, a new YouTube channel we formed in collaboration with the Midas Touch Network just before the election. So we'd be here on the other side. 50,000 subscribers have joined us since the election night because I believe they want to be at the busiest thoroughfare in our democracy, the one at the intersection of law and politics where we don't blow smoke or sunshine. If you want to know more about Legal AF, we have a podcast Wednesdays and Saturday nights at 8 p.m. Eastern Time. You can catch us recording it on live YouTube, over on the Midas Touch Network, and then on audio podcast platforms of your choice. And everything else, all things Legal AF, are over here on the Legal AF YouTube channel, along with other collaborators. So until my next Legal AF contribution, I'm Michael Popok, and I am reporting. In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories at the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.